Live from the offices of Great River Investments in the beautiful city of Burlington, Iowa, this is the Marvin Knows Finances Show. I am your host, Marvin Thomson, your certified financial planner, and joining me today is Joe Jolan of Jolan Media in West Burlington, Iowa, Todd Sladky, CPA, and my partner, Great River Investments, and our special guest today, Mio Santiago, attorney at Kozlowski Law Group in Burlington, Iowa. Thank you for taking a few minutes out of your day to listen in, and for all you listeners on Google Podcasts and Spotify, don't forget to click the subscribe button. If you prefer to see how we make this show come together, please check out our YouTube channel, Marvin Knows Finances, and click subscribe there as well. Just like the last and every time, I have to take care of a little business before we get moving too far forward to please my compliance department. Marvin Thomson is an investment advisor representative and a registered representative with Brokers Financial member SIPC. Opinions expressed in this program do not necessarily reflect those of Brokers Financial. The topics discussed and opinions given are not intended to address the specific needs of any listener. Great River Investments, LLC does not offer legal or tax advice. Listeners are encouraged to discuss their financial needs with the appropriate professional regarding your individual circumstances. Diversification does not guarantee a profit or protect against loss in a declining market. It is a method used to help manage investment risk. Mutual funds and exchange-traded funds are sold by prospectus. Please consider the investment objectives, risks, charges, and expenses carefully before investing. This prospectus, which contains this and other information about the investment company, can be obtained from the fund company or your financial professional. Please be sure to read the prospectus carefully before deciding whether to invest. So, we added a couple of extra disclaimers this week because of the question of the week. So, the question of the week is, should I invest in mutual funds or just do individual stocks? So, I had a client ask me the other day why we don't recommend individual stocks. And she had a very specific example. She said, well, my friend's investment advisor said I should be investing in the new Donald Trump media company. And they made a bunch of money off of that. And I said, well, we do not recommend individual stocks in our firm. And the answer for that is very simple. There's no diversification when you're investing in individual stocks. It's the whole put all your eggs in one basket. So granted, we've all heard stories about hitting the big one, kind of like going to the casino and you hear about the person hitting the jackpot when it comes to an individual stock. But literally over time, we have found that a diversified portfolio invested in mutual funds or exchange-traded funds is really a better way to go. Mutual funds and exchange-traded funds have many different stocks under or investment options under one investment. And like I said, we just feel that's the best way to go. There are plenty of programs out there now that if you want to play with some individual stocks, by all means, you can do it right on your phone. So it's in our firm, we tend to stick with the more broad diversified assets as opposed to doing individual stocks, but please don't let that persuade you from trying it on your own if you choose to. So today our topic of the week is elder law and care, and we've asked Mio Santiago from the Kozlowski Law Group to join us. So Mio, we're going to start out with some background information on you and your firm, please.
Sure. My name is Mio Santiago. I'm an attorney with the Kozlowski Law Group. We have locations here in Burlington and in Fort Madison. We're a full-service law firm here in Southeast Iowa. I practice primarily in the areas of estate planning, elder law, probate, and real estate. We've been here, or I've been here in Southeast Iowa for 15 years now as a practicing attorney.
Perfect. How do they get a hold of your law firm?
Our phone number is 319-753-6201, and our web address is I'll spell it out, KOZLAWLLC.com. That's CozLawLLC.com.
Perfect. All right, so let's talk about some very basic stuff. All right, on your website, elder law and care is listed as one of your things that you guys offer services for. Can you define what elder law is, please?
Sure. As we were kind of talking prior to coming live, elder law isn't necessarily one particular type of law. It encompasses a lot of different areas of law and principles. Broadly speaking, elder law is, as you could tell by the definition, the type of law that our aging population needs. And so that could range anywhere and include estate planning. It could include Medicaid planning. It could include elder abuse type cases, guardianships and conservatorships. So anything any types of, or all the types of issues that come up as you become older in life.
Gotcha. So that's really my next question: is when is this needed? I mean, honestly, we deal with a wide range of clientele's ages and needs and so forth.
Sure.
We're always happy to recommend them over to your law firm, and we've done so in the past, and specifically with a potential Medicaid type of situation. So when is it needed? I mean, when should people really be considering this? When mom or dad starts maybe having some memory issues, or way before then?
Right. As we discussed in a previous podcast, it should just be kind of part of a normal check-in with their estate plan. But how I typically see people, or when I typically see people, a few different scenarios arise. Child comes in with mom and dad saying, dad's going to be going to the nursing home. How do we qualify dad without having to spend all of my parents' money that they've worked their entire lives for? And that's what I consider crisis planning for a Medicaid standpoint. Then there's the proactive Medicaid planning, where we look and see how we can structure assets and put together a gifting plan. Maybe it might involve some irrevocable trust to, again, hedge our bets to make it past. There's a 60-month or 5-year look back period that Medicaid looks at, that any transfers during that time are presumed only for the purpose of not having to pay for your care.
Okay, so you're saying family members will come in with their parents or whatever.
Right.
And obviously you're talking about a wide range of issues, but the thing that I'm always concerned about is, as you get to a certain age in life, I don't know if you become more trusting or you're just not really thinking clearly on certain things, but how do you use this particular form of law to protect people from scammers? Big thing nowadays.
Yeah.
And what about family members who have bad intentions? I mean, what if I'm bringing my parents in with the sole purpose of screwing my two brothers out of stuff?
Right. Well, and
I'm not, by the way. Yeah.
Add that to the disclaimer. It's there's no 100% fail-safe way to do it, assuming that the people still want to have some control. Okay. You could definitely put a guard or a conservatorship in place to oversee your finances, and you wouldn't have, we could avoid any of your...
What does that mean? So
a conservatorship is a court supervised process where the court has determined that your decision-making capacity is so diminished as far as your finances that you're not able to take care of your finances on your own.
Can you name your own conservator, or is it a court-appointed conservator?
It's a court-appointed conservator, but as you have the ability to recommend a conservator, but that's typically as part of a power of attorney.
Okay.
While you were competent to say, here's who I would recommend should a conservatorship be necessary.
Okay. Now, I've actually seen conservatorships in place before with past clients, and the conservator had to go before the judge.
Yeah.
I think it was annually, and literally explain, if there was any questions about what's going on. I mean, it was a very simple process. The judge, as long as it was in the client's best interest, everything was good. But
think Britney Spears.
Yeah, that's been in the news lately.
That
that's a good one.
She's a young person.
Her father, had a conservatorship, and it, look at the mess that caused.
Yeah. Yeah.
So, that is one way. It's through a conservatorship. That's pretty heavy-handed, because then the person loses a lot of their ability to make any decisions.
They don't have any control once a conservative is in
Right.
place, right?
If they had a power of attorney, a financial power of attorney, you could revoke that at any time. You being the one that's under the power of attorney, but with a conservatorship, everything needs to be approved by the court. It's almost like probate for the living.
Gotcha.
Because the court oversees it. It's a public record, and that sort of thing.
Okay. One of the things that Todd and I uncover quite a bit is the idea that long-term care insurance is so expensive nowadays. I think it's probably one of the single greatest risk factors to destroying somebody's lifetime of work.
Absolutely.
Because if you go into a nursing facility and stuff like that, the costs are just getting astronomical. And of course, it also depends on the level of care that you need.
Right.
So how do you work with your clientele on protecting from long-term care expenses, and what are some of the tools you might use for that?
Sure. A little background and to kind of support what you just said, Genworth Company puts out a report, and they said about 75% of the population will need some sort of skilled care or assisted living during their lifetime. Here in Iowa, to give a little bit of perspective, the average nursing home stay is about $7,500 a month.
Okay.
So, do the math, and you can see how a modest, savings and assets could be depleted pretty quickly.
So you're talking $90,000 a year pretty quick.
Right.
Okay.
So some ways to accomplish that, to kind of mitigate that, I think one of the easiest is the long-term care insurance. Get it while you're healthy, and I don't know
How do you feel about that? Because when we talk to clients about it, I mean, I warn them up front. There's a sticker shock, to owning long-term care insurance.
Right.
But even when you compare it, like if an annual premium for a couple is $4,000 to $5,000 a year, and you compare it to $7,500 a month cost, they
Right.
still seem to be like, I don't want to do that.
Yeah.
So,
I mean, how I walk my clients through it is we'll do the math. We walk them through the math and say, okay, you've got X amount in retirement. You're paying $90,000 a year. How long do you have until that's all gone? How important is it to you to be able to pass some of that along to your children or loved ones?
Yeah.
Or the surviving spouse.
Or the
remaining
surviving
spouse at home.
Yeah. So, without getting too deep into the weeds, there is some set-asides for a survivor, for a spouse that's not in the nursing home, and I don't know how deep in the weeds we want to get into this.
we'll stay pretty high level.
Yeah.
This conversation.
But there is some planning. That's how I walk my clients through.
Okay.
It's you spend your entire life, busting your butt to save what you've saved. And do you want that to have to go to pay for your nursing home stay? Because odds are you're going to be in a nursing home.
Gotcha. So outside of long-term care insurance, what other tools? I know you and I have talked a little bit about using trusts,
Yeah.
stuff like that.
Right. So there is, gifting as a component to start to be able to gift to whom you want to go to. The problem is, as I kind of touched on earlier, there's the 5-year look-back period, and you'll be assessed a penalty for any gifts that you give during the 5 years preceding you entering into the nursing home.
Okay, so can I ask you a question about that really quick?
Yeah.
I think, and I might be wrong on this too, but I don't think I am. There's kind of a misconception that if you gift somebody something and then you go into a nursing facility in 5 years, they do the look back on it and they find this gift, that they want the gift back from the family members. That's not how that works, right?
No,
They
it's
take basically the value of the gift, off
Right.
of whatever you would be receiving.
right.
So
So,
if you're my son and I give you $15,000 this year, 3 years from now I'm in the nursing facility, they don't go back to the son and say, give me the $15,000.
no, basically what they'll do, there's a penalty divisor, as they call it. They'll take the value of the gift, divide it by 7,500. And so in that instance, it would be, 15,000 divided by 7,500 would be 2. So you'd be disqualified from being eligible for Medicaid, at least a nursing home component, for 2 months.
2 months.
Yeah.
Okay.
So they run a calculation like that.
Any idea where that number comes from? Is that just the government randomly picking an arbitrary number?
It somewhat equates to the cost of monthly nursing home stay.
Is it different per state?
It is.
It is. Okay.
Yeah. So with Medicaid, and I know we've jumped straight on into Medicaid discussion, it's a federal program that it's administered by each state individually. The states can make laws that differ from the federal regulations. It can't be more stringent, but it can be more lenient.
Gotcha.
So gifting is another another technique that we can look into, but we also want to plan for that penalty period. So gifting, or I don't recommend gifting too much because again, there's so many factors as to who you're gifting to. As we spoke in the previous podcast, what are the ages of the people that you're gifting to? Substance abuse problems, gambling problems, special needs. Are they ready for the money right now? So gifting, you lose all control with that, and it's theirs. If we do it through an irrevocable trust, it gives you the ability to appoint trustees and to be able to manage how they get that a little bit more.
Explain the concept of preserving dignity for clients. It was one of the things I put on my list.
Sure.
What does that mean when it says, we're going to help you preserve dignity in this case?
It gives you the opportunity while you're still able to say how you want your end of life to look like. That's touched upon by the living will and the power of attorney. There are, you could set forth how you want your funeral to look like. Do I want everyone to wear name tags so everyone knows who each other is, so they don't have to have that awkward moment, oh, who are you? And you can just focus on me, talk about me.
What a great idea.
Or if you want to be buried in a particular cemetery, or, what do you want to wear? What music do you want? Those are parts of things that you can accomplish through this as well.
So back on the gifting thing real quick, a client came in the office this week, wanted to gift monies to her kids. And I asked her two questions. I'm like, have you prepaid your funeral? And do you have long-term care insurance in place? The answer was yes to both of them. At that point, I said, let's go ahead and gift.
Okay.
Yeah.
And you beat me to it. That was going to be the other component that you could invest in is prepaid burial.
I think prepaid burial's a fantastic idea.
Yeah.
I mean, it's just, like you said, the dignity part of this and keeping control of what you want and exactly how you want. Because, son or daughter goes into the funeral home and they're all emotional, and next thing you know, you're being buried in a gold casket. So,
yeah.
Which may be what you wanted, but,
hey, you get to say. If you've done it, you get to say what happens.
Yep. So I went on to Google and I came up with a list of questions here that I wanted to run by you here. Okay. So I don't get to take credit for these, unfortunately, but the first one is can my loved ones sign legal documents if they have been diagnosed with dementia?
If they have legal capacity, then yes. And what does legal capacity mean?
That's exactly right.
Legal capacity is, do they have an understanding of what what they own, what their finances are like? Are they able to manage their finances on their own? Do they know who their loved ones are? Do they know who their children are and where they're? So, yes and no. Just because you have dementia doesn't necessarily disqualify you. So, I mean, it's a massive gray area. But, I would say if you're able to do that, you're probably better off doing a power of attorney and letting someone else do it.
Gotcha. In a previous podcast, we talked about 4 or 5 core planning documents, but would you mind reviewing those again for everybody?
Sure. I break them up into 3 pillars. The first one is what happens to your stuff when you die, and that's what most people think about as a will or a trust. The second are powers of attorney for your financial decisions. Who can make financial decisions on your behalf? You would appoint an agent to do that. And then the third one kind of has 2 components. The living will, which you basically state you value the quality of life. You don't want to be kept alive if there's no likelihood that you're going to recover. And that gives directions to the loved ones that you leave behind. And the second part of that pillar is a medical power of attorney who could make medical decisions on your behalf when you're unable to.
Beautiful. We might have already answered this question, but what do you think the single greatest threat to the financial future of people is?
Nursing home care and paying for it.
Yeah. Totally agree with that. Are there attorneys who specialize in elder law? And the reason I ask this question is, when you Google search something like elder law, first 10 things that come up are ads for attorneys, So, is there anything that our listeners should be aware of when they're talking to an attorney? Are there law firms who only specialize in this? Are they trustworthy? Those are the types of things I really want my people to understand
Sure.
and listen to.
There are, in the state of Iowa, we can't classify ourselves as a specialist in any one particular area. There isn't a certification process to be, at least in Iowa, an elder law attorney or a criminal law attorney or whatever. But you could look at their website. You can see, what sorts of topics they're covering. But yeah, I mean, there are certain firms that's all they do is elder law and estate planning.
They're totally trustworthy. They're going to be trusted 100%.
It depends on the firm, but yeah.
Okay.
I mean, they've, I would look at their website and talk to them and figure out how they develop their expertise, how long they've been doing it, what's their methodology, and you'll kind of get a good idea at that point.
Are there any dementia-specific provisions for a power of attorney that should be added or could be added?
Not necessarily. For powers of attorney, I think the big decision is they decide, at least for the financial power of attorney, they have to decide if they want it effective immediately. Meaning, if I appoint you as my agent under a power of attorney, if we make it effective immediately, once it's signed, you could take a copy of that to my bank and say, hey, I'm Mio's agent under this power of attorney. I want, access to his records, or he wanted me to pay this or pull this money out, versus when, some triggering event, whether it's, your physician certifies that you're unable to make these decisions on your own, then it would trigger.
Gotcha.
So that's why there's not necessarily a dementia component.
Okay.
But if you do it, if you trigger it when your physician makes that determination, then it'll be up to he or she.
Okay, sounds good. The next question, I wrote it down, and I'm kind of confused by my own question here, so I apologize if this doesn't make sense, but it says, do my documents ladder successors, or do they make use of a co-agent?
Sure.
I'm glad the attorney understood that.
Yeah.
I don't know why you're talking
Well, thank you, Mr. Google, for your question. So what that's getting at least how I'm taking that, is, does it make more sense to set a tiered structure of, let's say, an executor? For example, I want Jim to be my number one executor. If he's unwilling or unable, then I want Bill. If he's unwilling or unable, then I want Betty. Okay? So each one of those people, so whoever I said first, Bill, I don't remember, the primary executor, if he's unwilling or unable to act in that capacity, then it would go down to the successor executor.
Gotcha.
And so on and so forth.
That's exactly what I thought it meant.
With a co-trustee or a co-executor, they both have equal powers at the same time. And so while they're both living, or while they both want to act in that capacity, they have equal say, and that can cause some tension and cause some rifts. But then when one is, let's say Jack and Jill, we name, and Jill doesn't want to do it, then it would just fall on Jack.
Okay. Now you're bringing up a good question, or a good point here. You don't, just because you're named as the executor, don't mean you have to serve as the executor.
No.
Is that correct?
Nope. There's nothing that's requiring you to do
So
that.
just like you can disclaim an inheritance, you can disclaim this job. Probably the wrong term, the disclaiming, but
No, that's
is
what
that
we.
the right
Yep.
one? See, I could be an attorney. Okay, so I originally had a question, but it didn't apply to the state of Iowa. So I'm going
Correct.
to kind of flip it around to
Okay.
to what we can do in the state of Iowa. So let's say I have a client who owns a house outright. She does not want the house to be part of her estate when she passes away. So in the state of Iowa, what can a person do to basically give the house to the kids now? Okay. Is it something as simple as filing a quitclaim deed? Or how would they go about doing that?
First of all, I wouldn't advise that.
Is it because of the liability that might be imposed upon the two children who would inherit the house, or how would that work?
For the purposes of the 5-year look back period,
Gotcha.
and losing all control over the asset while she's living.
Okay.
and then whoever you gift it to doesn't get a stepped up basis. They would get, your basis versus if they inherited it either through a will or a trust, then upon your death, at least for now, who knows what's going to happen, you would get the stepped up basis. So, depending on how long you've owned the home, that could be a big deal.
Absolutely.
So I don't recommend that to happen very often.
Good. I'm going to circle back again and talk about the gifting real quick here, okay? The law says basically you can gift up to $15,000 per person to as many people as you want to. But some people are under the misconception that you can't give more than that in a single given year. You can, but there's a form they have to fill out with the IRS that goes against their lifetime gifting.
Yeah, I would defer to the tax guy. With that.
Mr. Todd.
It starts eating into your
Lifetime
your
exemption.
Lifetime exemption,
Okay.
and it would be a gift tax return. And I'm digging back in the recesses of time, but I think it's Form 706.
Okay.
And I don't think it's that complicated to do, but it's not something that people are familiar with, like a 1040. So you probably would get professional help to do that.
Absolutely.
So you did it right. But yeah, you're going on record with the IRS that, hey, I have started to eat into my lifetime exclusion.
Whereas the $15,000 does not eat into the lifetime exclusion.
Right.
Gotcha. So, Mio, is there anything else you would like to say about elder law, care, process of it?
I mean, I'll circle back to kind of the main areas that I've been doing as of late, and that's the Medicaid planning. And there's two different scenarios where that comes up. The first, and I may have already touched it, but I'll expand a little bit more. The first is what I call crisis planning. Husband is in the nursing home already and just paying privately for the nursing home stay. Wife comes in, or wife and child, how can we do that? So I do a lot of planning to structure their assets, help them with the spend down, because to qualify for Medicaid, you can only have $2,000 worth of assets. To determine, help them with the spend downs, how to spend it down to that level. Also to determine if their income is too high. There are things that we can do in forms of different trusts to do something with that excess income to qualify them for that limit. There are also things that the spouse that's not in the nursing home can sometimes pull income to get their income up to, it's called the minimum monthly needs allowance for the spouse that's not in the nursing home. So working with them through the intricate rules of Medicaid and who's administered by DHS here in Iowa, with the sole purpose of getting them qualified as soon as possible. So that's crisis planning. That happens. An immediate need. We need to get them. Eligible at the first of next month, because it's a monthly process. And I will work with them with the Medicaid application. It is pretty cumbersome as far as documentation. Work with them through that and structuring it properly. So that's crisis planning. And then there's the proactive, where they don't need it right now, but they're anticipating, at some time in the future, how can we structure our assets to protect them from Medicaid.
Gotcha. How does everybody reach you again?
Phone numbers 319-753-6201, www.causelawllc.com.
Thank you for joining us today.
Thanks for having me. I'm looking forward to hearing my voice ×2 speed on my podcast.
Perfect. As usual, my heartfelt thanks goes out to all of you for listening today. Special thanks to Joe Jolin, Todd Sladky, and Mio Santiago for joining me today and providing their amazing feedback and information. We want to hear from you, so please reach out to me by either giving me a call at 319-576-2264 or visiting our website at www.greatriverinvestments.com. Go to the contact us section of the site, and I or a member of my team may be in touch with you shortly to discuss our next steps together. Thank you again for listening to the Marvin Knows Finances Show. This has been Marvin Thomson, your certified financial planner. Have a great day.